This is Francisco Sirvent. I'm the founder of Keystone Law Firm. And today in this video, I'm just going to share with you how to fill out and complete a general durable power of attorney that will help you take care of financial affairs. Now, you can read all about this on our website at keystonelawfirm.com. If you run into trouble, feel free to give us a call at our office, 480-418-8448, and our team will help you with your first step. Our office calls that first step a discovery hour, so that is what they will point you to. But let's get right to it. So the form that we're going to be looking at is not one that we use or that we draft for people. This is one that comes from, actually, it's a free form online, and it's provided by Maricopa County Superior Court, and you can get it at their website, superiorcourt.maricopa.gov. And if you just look in the notes here or down in the comments, you'll see that link right there. You click on that, take you right to it, and you can pull it up on your computer, download, and fill things out. The form is 10 pages long, and it just goes through. First, it's got a set of instructions that I highly recommend you read. There are some seriously important things that you need to know about power of attorneys and how they work. First thing is that this is a general power of attorney. So this means if you sign this and appoint someone as your agent, you're giving them power to do anything you can do with your money, your property, your finances, okay? So if you can do it, they can do it. So you want to make sure you name only somebody you trust. That person you name, they're called the agent, okay? Now, in some circumstances, you'll see them called the attorney in fact, but that's the same thing, okay? This is just power of attorney for finances. Read through all those instructions and make sure you understand what you're doing here. Now, this is just another little form that'll give you the tools to know what's in here. Okay, instructions. Just so you know what you're looking at, a person who's the principal signs a power of attorney. It has to be in front of a notary, okay? To give a trusted and willing person, your attorney in fact or your agent, authority to act in place of the principal. That means they can do stuff for you. Generally, you only want them to do this if you are disabled or you're incompetent, not just, hey, go to the bank for me. This is if you are incompetent. Okay, so a regular power of attorney has a beginning date and ends either on the end date when it's revoked or when the principal becomes unable to handle their affairs due to sickness or injury. This one, however, is a durable, that's the magic word here, and has no specified end date. It ends on the death or upon revocation. So you're allowed to revoke it if you ever want to. Also, with a durable power of attorney, if the principal becomes disabled or incapacitated, this document allows the attorney in fact, whoever you name as the agent, to continue acting as such despite the disability. Okay, so this just means that if you sign this and appoint somebody as your agent, they can keep going even after you are incapacitated. Some more instructions here. Obtain the form here. If you go to the court house to get it, they charge you, I think, $5, or you can just download it for free off of the website. Take it to a notary public. You do have to take yourself plus a witness, okay? The witness has to be 18 or over, should not be the agent that is there, that you're naming. And generally speaking, it's better if they aren't related to you, if they're not getting anything from you out of your estate, if they're not going to be making medical decisions for you, if they're not anybody who's going to get anything from you, basically, then that's the best kind of witness. You want them to be completely independent, a friend, a neighbor, a professional, somebody who's completely independent. Okay, then you're going to sign it in front of the notary. The witness will sign it in front of the notary, and then the notary will notarize it. Only after those 3 signatures are on there is this thing valid. All 3 have to be on there for it to be valid. You all 3 have to be in the same spot at the same time, okay? You don't need to make copies. I'm not a big fan of making copies. All right, this here, what you're looking at on the screen now, is the actual legal document. This is the start of the legal document. And you can see down at the bottom, it's page 1 of 3. There are only 3 pages for this particular document. So that's, once you finish, you fill it out and you sign it, the 3 pages are what you need to keep and use. You're going to mark one box. This is a general regular, has a beginning and end date, or it's a general durable, okay, ends upon principal's death or revocation. So normally speaking, if you're thinking, I want to take care of my dad or my wife or a family member who I need to help them with their bills, this is the document you're going to use for that, okay? Or I'm sorry, this is the option you're going to select for that. Then you're going to identify the principal. So first, if it's, if I'm trying to take care of my mom, I'll put my mom in this first blank, and the attorney, in fact, or the agent will go down here. If I'm trying to take care of my mom, I'll put mom up here, and I'm going to put my full legal name right here. Okay? So then fill in the rest of the address and city, state, and date of birth. Mark the sections that apply to you. All right. Principal hereby appoints the above named agent to act and perform the following general matters. So here's everything that can be done. I usually recommend that you select all of these boxes. You don't want to limit what they can do. If you trust this person, you're not worried. And I don't recommend you do this unless you highly, highly trust the document. Trust the person, because if you don't trust them, then you shouldn't be giving them this power. You just should not. I have seen people abuse the power here that should not have had it in the first place. If you haven't known them for 10 plus years, I would recommend do not put them on here unless you have every single reason to believe they have your best interest at heart, they have your family's best interest at heart, and a lot of times that they don't need your money. That's unfortunately a big factor when it comes to seeing who has taken advantage of people. So you're going to select those. Check the one type that applies to you. Is this, again, a general regular? Has a beginning and end date? If it does, then put those dates in these fields. If it's a general durable, then you'll select this one down here. And this document is operational and it's effective now. So you want to put that date now, or maybe someday just a little bit in the future, but generally speaking, you'll say now. And then compensation. This document doesn't allow the agent to be compensated for the job. And then it starts in with the signatures. So again, the principal is the one who has to sign. They are the one who's saying, I appoint you, the other person. I appoint you. So if it was me and my mom would sign, put her full legal name right here, mom's legal name. She would, and then handwrite the date, and then right here she's going to sign in person in front of the notary. The witness will put their full legal name here, and then same thing, they're going to sign right there. The notary will fill out all of this under section 7, and they'll notarize it. Once that's notarized, it's done. Don't try to go back and make changes. Just tear it up and do a new one. I promise you that will make things so much better. Now, what you need to know about this general durable power of attorney is it does not contain some authority that you might actually want as an agent, or you might want your agent to have. One of the biggest ones is the ability to plan for and protect your assets if you ever need long-term care services. What I mean by that is if you ever need assisted living or nursing home, those are very expensive. They can be $4,000 to $10,000 a month. The worst case scenario I had was someone last year whose dad was paying $21,000 a month. It blew my mind. But she was able to, she had the correct power of attorney form. It wasn't this one. And the one that she had was one that we drafted for clients. It includes it gives the agent the ability to strategize and plan so that they can protect your assets and and we got him qualified for Medicaid, for Altex, and they started paying that bill. Saved them over multiple six figures of dollars in fees from the nursing home. So This is just, it's just a court form. It's not, the end all be all, but it's a good, it's better than nothing. So get it done at least. And but it does not include that. That's an example of something it does not include. There's some other powers and things that it doesn't include. Of course, it is just a 3-page court form, but again, it's better than nothing. If you want more robust form, just give us a call. We'll get you going. Frequently asked questions. These are great. Please review these. You don't want to be accused of stealing someone's money, especially when you're acting as the agent on a power of attorney, because the agent, you are taking not just responsibility to pay the bills and stuff. You're actually taking responsibility to do everything for them that you wouldn't even do for yourself. That is the law with regard to these documents. So make sure you read that. Make sure you know what these are, because the adult protective services can get you in trouble if you don't do everything right. And a lot of times, honestly, the rest of your family can get you in trouble. So review that. Those rules should be helpful, and get that done. Once it's signed by all three, the principal, the witness, and the notary, it is legal. It's valid. You do not need to go to court. You do not need to file it or sign it. You don't need to file it or record it anywhere. It is valid immediately, and then you use it. You take those 3 pages around to the banks, and you do business. You have to do everything for the best interest of the principal, period. And if you have questions, if this isn't sufficient, if the person who needs to sign this, the principal, is not competent, if they do not have full legal capacity, then they can't sign it. Even if they can physically sign it, their signature is invalid. And so, don't try to pass that off. That is a crime in Arizona. So, if they can't sign it, then, there are other ways for you to be able to get the permission to help them. It's a lot more complicated and more difficult, but we do that every day, all day. And so give us a call if you need help with that, 480-418-8448, and we'll give you a hand there. Also, just for some tips and tricks, you get to hear my dog Rex barking in the background. Sorry about that. But you just to make sure this is just general information of an educational nature. Obviously, this is not legal advice for anybody's specific situation. This is supposed to just be helpful information. Please research and make sure you're doing things that are correct for you and your family. I recommend you get legal advice. Our office does do one-off consultations with our attorneys. There's a little bit of a process to get that when you're a brand new client, but we do make it as easy as possible, and we can get you scheduled. We'd love to do that if that's something you need. If not, just jump on this, and if that answers all your questions, we're glad it did. Again, Francisco Sirvent with Keystone Law Firm, and if you need something, just give us a ring. Thanks. Have a great day.